Thank you for listening to my documentary project for law. This is in regards to alcohol service laws and how they've changed. Prior to New York, in 1847, there was no dram shop laws in the United States. The first formal laws were enacted in 1858. But what made these laws necessary in the kind of temperance movement in general? And how have the laws evolved, or have they? Previously, there were no laws regarding alcohol consumption. If someone wanted to drink themselves into a coma every night, they had that right. The tavern keeper was allowed to profit from his choice. This created some issues, predictably, and in 18th century England, the public kind of grew tired of the public drunkenness, the number of rates of people that were abusing their spouses or their children, and just kind of the problems that are associated with chronic and rampant alcohol abuse. So they made some laws to kind of prevent it. The first recorded case of dram shop laws came to the U.S. in New York, 1847, but the first official, actual, written, codified law was in Illinois in 1858, which was holding tavern owners liable for injuries and damages caused by intoxicated customers. So the thought process here was that if your overindulgers were cut off at the source, then there would be less public intoxication. This was kind of an offshoot and part of the temperance movement in the 19th century, kind of brought about the dawn of more public protection laws. But we were followed pretty quickly after that by prohibition. Prohibition was a great idea. The thought was to ban alcohol and it would prevent all of these crazy problems. But it was repealed in 1933 because of a few reasons. They couldn't enforce it. There was an unprecedented spike in violent organized crime with your mobsters and people making illegal hooch, which created some other medical problems because people were getting dangerous and non-sanctioned alcohols. There was a huge lack of public support, and it was a massive economic loss from the tax revenue as well as job losses. So prohibition was done away with, and we went back to having dram shop laws. So these are civil liability laws that allow injured parties to sue alcohol serving establishments, bars, restaurants, liquor stores, for serving alcohol to visibly intoxicated or underage persons who later can cause harm. This would be drunk driving, assaults, you name it. The term dram comes from the unit of measure, which is a dram, which used to be used to measure alcohol. So the development of these laws to present, after 1933, we saw the repeal of prohibition, alcohol regulation was returned back to the states. The states began to reestablish their liquor licensing systems, but civil liability was pretty rare still. Most liability fell on the intoxicated person, not on the seller. In the 50s, we started seeing laws come up with statutory dram shop laws that were focused on serving minors. And then courts were following the proximate cause doctrine, which denied liability for third-party injuries caused by intoxicated persons. In an early case of Waynick versus Chicago, the last apartment store, in 1959, this is one of the first appellate decisions, which actually suggested a bar was liable for overserving a customer who later caused harm. The expansion of liability occurred in the 70s and the 80s. There was a lot more social attitude shifting regarding drunk driving fatalities. We saw the onset of Mothers Against Drunk Driving, or MAD. They were banning driving while intoxicated or driving with alcohol in your possession. And courts started to recognize alcohol vendors could be liable for injuries caused by intoxicated patrons if they were not careful. So this is when we see Vesley versus Sager in 1971 in California. The court ruled that a social host could be liable for serving alcohol to an intoxicated guest who later causes an accident. D'Amico versus Christie established a bar may be liable under certain circumstances. And many other states started passing dram shop laws regarding serving minors, visibly intoxicated adults, or violating regulations. The thought process here was that if you cut these people off before they can cause trouble, it would prevent later issues. By the mid-90s, most states had some form of dram shop law by statute or case law. They varied widely in scope. Some were just imposing strict liabilities for serving minors. Others were requiring proof of visible intoxication or proximate cause. but almost all of them place caps on damages and time limits for filing a suit. To present day, they're primarily state-level laws. There's varying degrees of restrictiveness. There is some protection for social hosts in some states, and immunity clauses for sellers who follow the ID checking laws. But the rising use of video evidence, POS systems, and employee training can either mitigate your liability or increase it. We have seen an increase in litigation involving ride shares, cannabis and alcohol interaction, especially in states like Washington, where cannabis is legal, and delivery service use. New York, Texas, and Illinois see a lot of litigation regarding dram shops, as does the state of Washington. COVID-19 actually raised a lot of questions about liability for third-party delivery apps, as a delivery driver is probably not going to be capable of assessing somebody's intoxicated levels, especially if they're just dropping and going. Some states, like New Jersey, actually holds establishments liable without proving any kind of negligence. They are still liable. There are some laws that apply only to minors with damage caps. Delaware and Kansas have no dram shop law, but most places have a duty of care where the server must not serve minors or visibly intoxicated people. Causation would be if the sale contributed directly to injuries and damages, a plaintiff must show injury or loss due to the intoxication. There's working on ways now to increase regulations for alcohol delivery services. They're using more technology to kind of track things, whether it be cameras, feeds, POS systems to see the level of service, and a lot more public awareness of your host liability. There's unlikely to be a federal guidance just because it's a state-run operation. I used to think that laws regarding liability for alcohol was kind of nanny state, and I still believe in personal responsibility. But after some of the crazy stuff I've seen working in the industry, we definitely have a responsibility to ensure the safety of our patrons. They're part of our community, and we have to protect them as well as others around them. When you include some of the other substances that happen to come up with the party scene, it creates a lot of problems, and we have to be good stewards of our environment, which includes our places of business. If somebody overindulges in their home or does something there, then that is definitely their choice. Whatever comes from that is on them, but if it can be prevented, we absolutely should.